May it please you, my lord. I want to move now to section C of our written case, which is the section where we deal with construing the introduction agreement. First of all, to say that our position here is that the Court of Appeal reached the correct construction on the facts, the relevant facts as found by the trial judge. It's important to note that this is a case with a short, informal, oral agreement, which was obviously incomplete in the sense of not covering anything other than the bare essentials that was discussed. And that's very important to contextualise not only this case and the submissions that we'll make, but also by way of contrast with the authorities that might be referred to, like Attorney General and Belize, and other cases where, and Marks and Spencer and BNP Paribas, where what was being dealt with was a detailed written agreement. Could I start by taking you to the High Court's interpretation of the introduction agreement, just to make some points about what exactly was found there in response to what was said on behalf of the appellants. Before I come on to the judgment itself, could you Lordships go to page 256 in the electronic bundle? And at the very bottom of page 256, as my learned friend says, this was a case, because it was in an insolvency application, there weren't any pleadings as such, or witness statements and then skeleton arguments for the final.
What are we looking at here?
So this is what was Mr. Barton's skeleton argument for the purpose of the final hearing before the judge. So here the terminology, the appellant, is applying to Mr. Barton, who is the appellant under the insolvency rules. And his case, which is referred to as PB in this document, is really set out at paragraph 13, where we say 13.1 that was an agreement to pay 1.2 million in the event of a completed sale, no reference to a purchase price. And we were relying in particular on an email that had been sent. Our alternative case is at 13.2, where we say that an alternative claim to 1.2 million or such other sum as the court considers as just restitution. We say on the next line, Mr. Barton says that whether or not there was a contract, he provided FoxPace with the introduction. And goes on to set out what was the basis of our unjust enrichment case. So that was our case. The FoxPace's case in response to that appears at page 280 in the bundle. I say in response, it was their case in their skeleton argument, which I don't have any independent recollection, but imagine was mutually exchanged. And they say...
Which page are you on now?
I'm sorry, bottom of page 279.
Thank you.
So the FoxPace said at this stage, any agreement was subject to contract, and then at paragraph 11 they're saying if for any reason there wasn't a subject to contract, then the trigger for payment was there was an issue about that. And at paragraph 2, they say if there was any right to repayment, it was premised on a purchase price of not less than 6.5 million. So they're saying that was the trigger for payment at that stage. Going then to the judgment, which is on the Judge Pearce's judgment at page 213 of the bundle. There's a number of paragraphs that recognise the rival positions of the parties on the contract claim, and they're paragraphs 3, where you were taken to these earlier, so I'll just give you the paragraph numbers. Number 3, number 16, to which you were taken earlier. And it's 16C, the respondent's case is said to would be paid 1.2 million if, but only if, the property was sold for 6.5 million. Not any payments at all, but 1.2 million pounds. Paragraphs 127 to 128 set out again what Mr. Barton's position was. It had to be the case at one point the trigger for the payment was a completion of a sale. And at 132 on page 234, that the respondent's position was that the only discussion was as to the payment of a fee of 1.2 million in the event of a sale of 6.5 million. And then paragraphs 144 and 150 then set out again the position of the competing parties. And he says that the competing positions which he has to decide were that the only terms, this is at paragraph 150 on page 238, the only terms discussed were as to the payment of an introduction fee of 1.2 million if the property was sold for 6.5 million. So what his lordship had in front of him was a case in which there was a competition between, well, what's the trigger event for a payment of 1.2 million pounds? Is it that there was a sale, or is it that there was a sale at 6.5 million pounds? That was the issue that he was deciding at this stage, because of course at this stage no findings have been made about what the contract was. So when his lordship is looking at paragraph 153 at Mr. Rook's version of events and Mr. Barton's version of events, he is deciding the terms on which payment of the contractual fee of £1.2 million was due between those two rival positions I've mentioned. He wasn't at this stage considering a claim to a reasonable sum, whether it be in contract or unjust enrichment. So then when he gets to paragraph 161, which is the paragraph most relied upon by the appellants, and makes the finding that he does, he is simply finding, in my submission, that, well, the trigger for 1.2 million hasn't been hit, and that for that reason the claim in contract failed. He means the claim to 1.2 million pounds has failed because he has found that had a trigger of 6.5 million pounds. So all that this judgment is dealing with, when the appellants say there's a finding by the judge that he interpreted the agreement at 161 objectively as meaning that there was no entitlement to payment. Payment there has to be seen as payment of 1.2 million pounds. It's apparent from his lordship's judgment that he isn't there saying no right to payment of anything at 161. And to the extent he does say that, of course, there's no engagement with the objective interpretation and the usual authorities that one looks at to look at that. It's consistent with him simply having made a finding of fact about what a trigger was for the payment of 1.2 million. So we say, therefore, that the judge's relevant findings of fact are those that are set out at paragraph 33A to C of our written case, which is at page 151 of the bundle. And I look at those only to note that the contention put forward by the appellants is that His Honour Judge Pearce accepted Mr. Rook's version of events to include a version of events that there was an agreement that it would be paid only if there was a sale up 6.5 million. But that wasn't, in fact, Mr. Rook's evidence. Mr. Rook's evidence is at paragraphs 108 of the judgment. There's reference to his witness statement. This is page 230. And he says that, paragraph 17, he said Mr. Barton had approached him with a proposal that if Weston ultimately purchased property for 6.5 million, then he might be paid 1.2 million pounds out of proceeds. So then he goes on to say how he felt about that. Because, of course, their case was whether there hadn't been any positive agreement reached. So he was a little bit, he wasn't very forthcoming on that and saying, well, this is how I considered that to be. And I wasn't averse to it. But he doesn't say, and I said, or either party said, only if of payment, or the payment is conditional, or words to that effect, or any payment is conditional. And then at paragraph 111 of the judgment on page 231, the judge records that Mr. Rook's evidence in cross-examination was that there was no discussion about what would happen if the sale price were less than 6.5. So when His Lordship goes on to say he accepts Mr. Rook's version of events, that has to be read in my submission by reference to what his evidence had been. And it certainly wasn't that the agreement was only if. And he deals with that at paragraphs 153 through to 157. So what we say is, well, the only findings of fact he actually makes are those that we set out in paragraph 33, which are all findings of fact that help you construe the agreement in the way that the Court of Appeal did and in the way that we do. In making that finding of fact, he did reject Mr. Morris's evidence, and we say that is a objective assessment of the case, because what Mr. Morris was reporting was what he'd been told by Mr. Rook about what the agreement was. And His Lordship was expressing surprise, was saying that he would have expected Mr. Morris, as a solicitor perhaps, to express surprise at such an agreement. Not that he expected him to express surprise at Mr. Barton having said that was the agreement. That isn't what he says, and it's not a fair reading of what he says in my submission. And that's actually your best indicator of what His Lordship considered of the objective interpretation of the agreement that he had found. The written case deals with...
how does he come to the finding then at page 238 that either version was possible and neither would be illogical?
Yes. Well, there's a difference in my submission between something being logical and something being commercially bizarre. Something can be perfectly logical, but as in strictly makes sense as a matter of process, but nevertheless be a bizarre thing to agree to. And that, of course, is the notion of commercial common sense is what it's all about. It's not the same thing as common sense, it's commercial common sense. And in my submission, what the judge is dealing with there...
Why was it bizarre?
Sorry, my lord.
Why was it bizarre?
Well, we deal with that at paragraph 18 of our written case. Page? Page is just... Bear with me, sorry. Page 147 of the electronic bundle. And we say, well, first of all, you have the possibility that a sale could take place at less than 6.5 million and then we receive nothing. Now, of course, it's right to say that a term could be implied to prevent bad faith, but not every reason why a sale would not complete at 6.5 million would necessarily be bad faith. There might be lots of reasons it wouldn't complete at 6.5.
You accept that that 1.2 million is greatly in excess of a reasonable fee?
It was calculated by reference to what was...
But it's greatly in excess of what has been held to be a reasonable fee. You're not taking issue with the 435,000.
No.
Right. So the contract that the judge finds, there's a kind of equal balance of risk, isn't there? That if it's sold for 6.5 million, well, Mr. Barton takes the risk. He wins the big prize if it's sold for 6.5 million, but he gets nothing if it's sold for less than that. And that's matched by the risk and reward for Foxpace. They risk paying substantially in excess of a reasonable fee if it's sold for 6.5 million, but they have the prize of getting the introduction for free. But if the contract is as you say, it's a one-way bet for Mr. Barton, isn't it? He gets the great prize if it's sold for 6.5 million, but then he also gets a reasonable fee if it's sold for less. And conversely, it's a bad bargain in both respects for Foxpace. They risk paying 1.2 million, but then they don't have any chance of getting the introduction for free. So doesn't it rather unbalance the contract if Mr. Barton gets paid either a huge amount or a reasonable amount, whatever happens?
Well, we say no. Of course, it comes down to construing what the real terms of the agreement are. And the position is that Mr. Barton takes a risk, but he takes a risk that there's no sale at all, in which case he doesn't get paid anything. He takes a risk that the sale is less than, on an objective assessment, he takes a risk that if the sale is less than 6.5 million, then he's reduced to claiming a reasonable sum in contract or in unjust enrichment. Those are the risks that he should objectively be considered to take. And there's corresponding risk there for Foxpace as well, because again, Foxpace take the risk that if the purchaser reduces the price, then they are either in a position where the law puts them in a position of paying a reasonable amount, or they have to go and renegotiate. So those are the two risks that balance off, we say. On the correct construction, you have a balance of risk. On the construction that he just gets nothing, it just doesn't make sense, because Mr. Barton does the work, provides the valuable thing, but at the risk of getting nothing. And in fact, the higher the fee, the greater his risk perhaps of getting nothing, because there's the increased incentive for someone to seek to avoid paying him. Not that that happened in this case, but you're looking at how to interpret the contract at the time it's made. So we say looking at things realistically, not with hindsight, but looking at things objectively at the time a contract was entered into, the commercial and common sense interpretation of this agreement is the one that we put forward, that there was a particular agreement about a particular price, which, yes, Foxpace are happy to pay an enhanced a figure that's not calculated by reference to any risk anyway. As we know, it's calculated by reference to Mr. Barton wanting to recover his lost deposits. But that doesn't then exclude what would be the common sense position that he's entitled to a reasonable sum in any event. And it's not heads he wins, tails Foxpace lose, because in both scenarios, Foxpace gets a valuable benefit that they wanted to get from Mr. Barton on terms where they knew he expected to be paid for them. So they get the benefit of the introduction, and yes, they have to pay a value. They have to pay the market value for that introduction, but that's not a one-way bet. That's a bilateral situation where both parties get what both parties should get, which is something valuable has been provided. The provider of that should be recompensed.
If the words "if," but only if, but only if had been included, is that the end of the case?
No, I agree with my learned friend that it's always a question of construction. As I say, I'm using if but only if more as an analytical tool to make the distinction between the two.
So even if those words had been included in the actual contract that was entered into between Mr. Barton and Mr. Rook, there would still have been a claim for unjust enrichment or an implied term for quantum merit if the property was sold for less than 6.5 million.
Potentially, but it would be relevant matter to take into account in the construction, because of course if the words only if are added, then they are added for emphasis, supposedly. You then still have to construe the agreement in all of the circumstances to understand what those words mean in those circumstances. So I don't say it wouldn't be a more difficult position for Mr. Barton, but nor do I say it's crucial either way, other than analytically.
If it had said you'll get a fee if and only if there's a sale at 6.5 million and that fee will be 1.2 million, then you would be dead in the water, wouldn't you?
Almost certainly, but it would. I have to come back for consistency purposes. I have to say, well, it depends on all the other factors, and you've got to construe the agreement in the round. But it would be very difficult in those circumstances to say that. And that's why we've used the analytical analysis we have, which is to say we accept if this is a contract where you take the view that Mr. Barton and Foxpace agreed, if and only if, that emphasis, he was only to be paid at all if the price of 6.5 million was done, then we accept that we would lose in that situation, but not otherwise. Just in answer to, I'm going back a couple of questions, but in answer to the question about bizarre, I also adopt what Lord Justice Males says at paragraph 57 in the Court of Appeal, his judgment. We've mentioned in our written case Carmichael and Thorner in relation to taking into account the subjective findings of court. I'm not proposing to take your lordships to those cases. We deal with them in our written case, but in essence what we say is this is a case where you can take into account, and the judge made findings about what the parties' intentions were or understandings of the agreement were, because it's an oral agreement and that helps you to find what the terms may be.
Yes, well, I appreciate you're under time constraint. If you just want us to read Carmichael, we will. But speaking purely for myself, I'm in some difficulty in seeing why the rule that you don't consider the parties' subjective intentions is any less applicable to an oral contract once you know what the words used were than they are to a written contract.
Once you know what the words used are, yeah.
I can quite see they may be relevant to the factual question as to what they actually said to each other.
Yes.
But beyond that, they're of no relevance, are they?
Yeah, so there's always a fine line in a case of oral agreement between with what the judge has actually done when they've made a finding, because he's found what the agreement was without necessarily finding those were the express words that were spoken. And so there is margin in my submission to then look at, well, what did the parties think they were, what do they think they were agreeing to? And he's made a finding of fact as to what their subjective intentions were.
That's my understanding of Carmichael. I mean, if you know what the exact words were, then it's just the same as if you had a written agreement.
Yeah.
Yes.
But if you don't know what the exact words were, then there's a question of what was agreed, where it's relevant in deciding the thrust of the substance of the agreement, if you like, to know what the parties thought, because that has a bearing on what actually is likely to have been said, precisely.
It affects the probabilities as to what the words were.
Yes, I think Lord Hoffman says it helps you to ascertain what the terms may be. It's some evidence of what the terms may be. And yes, if you found what the terms were, then it falls into the background. But my submission is that in this case, what the judge has found is what the agreement was without necessarily finding what the exact words were said. And so there is some margin to look at what did they consider. There's also this margin to look at it, which is that where you have a brief oral agreement like this, it is somewhat unsatisfactory, although possible intellectually, that the court reaches a interpretation of the agreement that's at odds with what the parties understood the agreement to be. And so it's especially important in a case like that a contrary construction to their understanding is arrived at by a process of going through the usual considerations that have been set out in the case law on interpretation of written agreements.
The difficulty with that is that where both parties take an extreme position, as they did, one saying there was no contract at all, the other saying that the 1.2 million was payable regardless of the price, then when the judge finds the fact that it was something in between, he is finding that it was not at least what they say now was their intention at the time, but he's finding that that was their intention at the time, albeit they are both disavowing that for the purposes of the trial. Isn't that what happened?
Well, he still went to look on at the issues in the context of what was the unjust enrichment claim, and we say he undertook the wrong exercise there in reaching the conclusion that he did. But the question still remains: how should this contract be interpreted? And what we say is it can be interpreted based on what the judge's findings of fact were by an appellate court in the way that the Court of Appeal did it. Can I move on to the question of silence? It's been suggested that silence is definitive, essentially, by the appellants. In other words, where the contract doesn't say that we're entitled to something at a sale less than 6.5 million, then we don't get anything. That must mean we don't get anything. In my submission, silence without context is logically neutral. It must be. Where the contract is silent about a particular matter, that can't automatically mean that it doesn't cover it. Otherwise, my lords, there'd be a lot of perfectly good brief oral agreements that were fail for want of certainty. Many agreements don't cover matters, but they're not found to not be a valid agreement because
that's usually because of a fairly generous implication of terms.
Can be, my lord, but not always. It can be because of you have to construe an agreement in the way it falls to be construed. And I want to look at Diwali and Wells on that point, which of course will be familiar to your lordship. It's at page 522 of the authorities bundle. As the court no doubt knows, this was a case in which the Supreme Court overturned the Court of Appeal's majority decision, the brief oral agreement between an estate agent and a vendor, which specified the agent's commission at 2%, but was silent about when it would be paid, was held too uncertain to be legally binding. And the court in this case, Lord Kitchen, giving the judgment on behalf of himself and other members of the court, and my Lord Briggs, giving a further judgment agreeing with Lord Kitchen and adding some assessment of his lordship's own, ultimately found that this was a case in which there were common understandings of when agents would be paid on such transactions, and that those common understandings could be given effect to, and the contractual construction route, like in Chartbrook and Persimmon, was preferred as the solution, but an implied term was also said to have been possible. And particular passages I wanted to take the court to. Paragraph 19 on page 534. Where the court held that, this is about 2 lines below letter G, whilst it's true that the judge found there was no discussion of a precise event which would give rise to payment of that commission, but absent a provision to the contrary, I've no doubt it would be naturally understood payment would be due on completion and made from proceeds of sale. That seemed to be the only sensible interpretation. His lordship then goes on to look at some of the older estate agency cases to a similar effect. Midgley Estates and Hand at paragraph 21 is of interest because it deals with the converse situation where there was in fact an express term that the court ultimately decided meant the position was different, and it was held that the Court of Appeal held, this is just above the quotation under letter E, that the terms of the agreement were clear and the court would give effect to them, and they displaced the prima facie position. And so what we take from that is that where the court is satisfied there is a common understanding or a default position, a particular course of business, that it takes clear terms in the contract to displace that common understanding and position as a matter of construction of the agreement. And to a similar effect is Dennis Reed, paragraph 22, where again common understanding is referred to in the quotation. And at paragraph 23, Lord Kitchen says that all of that reasoning remains cogent, and he endorses it, and that the case before the court was another one in which the parties meant by their words and actions that the agent was engaged on the usual terms. And paragraph 26.
Now, is that an example of terms being implied by law into a contract of this type, subject to contrary intention?
Well, the question of implication of terms by law is a difficult one sometimes, my lord, and I'm careful how I tread in that regard.
Well, it's just that Lord Kitchen says on the usual terms. And he cites cases where there may be, the parties may have it very clearly contracted out of the usual terms, but otherwise the usual terms apply.
Yes.
by usual must mean usual for this type of contract.
Yes, in my submission, yes. And so I say equally in a contract for the supply of services, a usual condition is that you're entitled to a reasonable sum unless you've got an express agreement about the price. We'll look at it in another context when we come to look at implied terms about what Lord Bingham, I think it is, but I'll correct myself if I've got that wrong, says in the Phillips and BSB case about such clauses. So I don't want to move away from Devaney and Wells until I've just picked up the last couple of quotations, but I'll come back to that point if I may. Certainly, it doesn't say anything in this case about it's a matter of implication by law. What the judgments say is that one looks at what the common understanding is of an agreement of this type, and one uses that to interpret the contract in question. I say that applies equally to reasonable remuneration for provision of services. It also applies in this case, of course, because what we say is, well, Mr. Barton's achieved a sale. He's introduced a purchaser who's purchased the property. Might have been less than the price that was mentioned in the contract, but he's achieved what normally an introduction agent has to achieve in order to get paid, which is he's introduced a purchaser who's purchased the property. And then there's another common understanding that goes alongside that, which is, well, what are they paid? Well, it's a reasonable remuneration. And I'm afraid I don't know if any of these cases were ones where the amount of the commission wasn't agreed or not. But if one's to imply the common understanding of payment, it's just simply the next step to imply the common, or say imply, construe, or imply the common understanding for reasonable remuneration if there's no figure. So just going back to paragraph 26, Lord Kitchen deals with...
It doesn't really matter whether the person is an estate agent or has absolutely no qualifications or no background at all. Is that right or not?
Well, I say...
Usual terms would be implied.
Yes, well, again, sorry to keep saying the same thing. It all depends upon the correct construction of the agreement. But in my submission, it shouldn't make much difference now.
Well, the point is it's a commercial context in which the ordinary expectation is that people get paid for what they do and they don't just come along conferring benefits on other people out of goodwill and generosity. Yes,
well, and that's what we say in our written cases. Or what we say, because it's said against us by the appellants, that the reason why it was important that Mr. Firth was an estate agent, or it was important in Firth and High Lane that Mr. Firth was an estate agent, we say it was only important to explain that he expected to be paid. And you can take that from, as my Lord Stevens said, you can take that from almost anything where you're providing a service. Certainly you could take it here, because Mr. Barton was quite obviously in the business of dealing with property, and he was also quite obviously providing this for reward.
Can I just pursue that? And I'm again going back to where exactly we get this implied term by law from. As I say, my understanding is that you would be looking at types of contracts that typically would standardise almost this type of implied term. And as I say, I think the classic case on that is Liverpool, CC and Irwin, but there may be many other cases. But as I understand it, your submission is that applying that analysis, the type of contract we're here talking about is as wide as saying all commercial contracts for the rendering of services. That is the type of contract we're talking about, that they trigger, unless excluded, an automatic implied term by law of reasonable remuneration. Is that correct?
Well, I've not used the terminology that is implied by law so much as to say that in these types of contracts, those terms are customarily implied or customarily construed. I say, yes, there's two potential avenues here. First of all, there's the provision of services. And I say, well, look at Section 15. I say Section 15, had the opportunity to have a look at Section 12 over lunchtime. I say Section 15 does apply to unilateral contracts. So that tells us that where a party provides services, they are customarily entitled to reasonable remuneration for those services unless the contract says otherwise. That's been the basis of cases decided on quantum merit or reasonable sum for hundreds of years. So that's one basis. The other basis is that Mr. Barton, as I say, was providing an introduction to a purchaser, and then we have the cases of the type summarised in Devaney and Wells.
I think it has to be a narrower basis, doesn't it? Because it is well established that simply providing the service of trying to find somebody does not entitle you to a reasonable remuneration in a context of sale introductions.
Yes.
The custom, if you want to call it that, or the commercial expectation is that you'll get paid if you succeed in finding somebody who then does buy the property and confers a benefit on the seller.
Exactly.
But you've got no general expectation you'll get paid for the work you do otherwise.
No, my lord, exactly right. You have that expectation to be paid and out of the proceeds of sale as well as your usual expectation, to make it abundantly clear. It's completed sale out of the proceeds of sale. And in my submission, it's important not to run Mr. Barton's case together as if it were a case where he's saying he's entitled to be paid in any event. We don't say that. We've always accepted that his entitlement to be paid comes from the fact that he introduced the purchaser who purchased the property. And for that reason, there's a value for the contractual analysis and also for the unjust enrichment analysis in the alternative. Threatened to take you to paragraph 26 a couple of times now. I'll take you to paragraph 26 if I may. It's Lord Kitchen, and this is just really his conclusion, which we rely upon, which is what a reasonable person would understand from the agreement. And I say really that's what it comes down to. What would a reasonable person understand from this agreement? It's not so much questions of implication of law or anything else. It's a question of, well, how would a reasonable person understand this contract, the officious bystander? And it takes me back to how I opened my submissions, which is a reasonable bystander would surely say, it must mean that he gets reasonable remuneration at least if it's a sale less than 6.5 million. So in this case, what the court did was, notwithstanding the silence about what a trigger was for payment, it construed the agreement to have a trigger for payment, which was the usual one, which was a completed sale. So we're looking at our case slightly differently. We've got the trigger, which is a completed sale, but it's silent about what should be paid at less than 6.5 million. And we say that silence should be filled by the same, by a reasonable understanding in the same way. The other case I've cited on this point is Aberdeen City Council and Milne, another Supreme Court case. And this is another case in which the court had to interpret what an agreement meant, notwithstanding there was some silence. It appears at page 701 in the authorities bundle. And the position here was that a developer had purchased land from a local authority and agreed to pay an uplift after completion in the event of either an onward sale, a long lease, or if it wished to buy out the authority's ongoing interest in those things, which they refer to as a profit share. The clauses of the agreement set out how the amount payable to the local authority should be reached in each of the events identified, and they're then set out in paragraph 7 of Lord Hope of Craighead's judgment. And buyout and lease were by reference to open market value, or with a slight difference between how that was described for each. But sale was by reference to gross proceeds of sale. And what happened was that the defendant sold the land to a group company at less than market value, so that nothing was in the event payable once allowable costs had been deducted. That led the claimant local authority to bring proceedings on the basis of its interpretation of the agreement, which was Well, first of all, so it was an appeal by the defendant. So the appellant's case was set out at paragraph 11, and then the defendant's responding case was paragraph 12. And Lord Hope essentially held that the correct construction of the agreement, and he deals with it mostly between paragraph 17 and 22 of his judgment, the correct construction was to look and say, well, the uplift in the event of sale was obviously to be calculated by reference to market value in the event that the sale wasn't at arm's length, so as to be consistent with the commercial purpose of the agreement. And he said alternatively he would imply a term. But the actual position on the words of the agreement was that gross proceeds of sale were defined, as you can see at paragraph 7, as simply the aggregate of sale proceeds. So there were no words in the agreement that led to the conclusion that gross sale proceeds would be interpreted to mean an open market valuation. And simply on the words of the contract, you might think it was quite to the opposite effect. And his lordship said that what had to be done in the circumstances was to consider paragraph 18. So he says the problem that the facts of this case give rise to is that it wasn't expressly stated anywhere in clause 9 or the definitions that the sale proceeds were only to be used in the open market value. So he had the situation referred to in some of the other cases of having to decide whether that was a deliberate choice or an oversight. And ultimately, he takes the view it was the latter and found in their favour. He considers at paragraph 21 an argument that was put forward by Martin Hogg, who's a senior lecturer at the University of Edinburgh. But why should the court do that where a party has allowed what might be said to be a commercially disadvantageous contract to be concluded, rather than just interpret the clear words of the agreement and allow the party to suffer the consequences? His lordship rejected that, said he wouldn't, for his part, view the present case in that way because the context showed what the intention of the parties must be. And I say that applies equally to this case. You can look and say, well, the agreement's silent, but is it a realistic interpretation to say that the parties objectively intended there to be no provision for reasonable remuneration in the event of a sale at less than 6.5 million? And just to say that they should have included a term doesn't answer that question. Lord Clark, for his part, preferred to deal with the matter by way of rainy sky. By way of implied term, but he referred to rainy sky in saying that, interestingly, no commercially sensible argument as to why it should be the position that parties should be left in the situation of ending up with just a clause that could be that would leave them with nothing in this case, rather than market value like the other two clauses. No sensible suggestion had been put forward as to why that should be so. I'm not proposing to take my lordships to rainy sky and Cook. I mean, we've cited that as well on the question of interpretation. What it's authority for is that where there's more than one meaning of an agreement, the part of the court should prefer the meaning that most complies with commercial common sense. We say that this is such a case, and therefore the interpretation to be preferred is the one that accords with a reasonable remuneration. So I'll move on to section D, which is implied terms. My lords, we support the Court of Appeal analysis that a reasonable remuneration is available in this case, either in contract or in unjust enrichment. We say it's one of those cases that it makes no difference to the outcome. We say, following Devaney and Wells and what's said there, that the contractual right to reasonable remuneration at anything less than £6.5 million should be reached by way of construction. But the alternative way to arrive at that conclusion, like in Devaney and Wells, is by way of an implied term. And as at as it was said in Dividing Wales at paragraph 29, anything else, leaving us without a right to payment, leaving Mr. Barton without right to payment, would be completely inconsistent with the nature of the relationship, which was a commercial one. We refer in our written cases, paragraph 64 to 81 of our written case, we refer to those common understandings and back to section 15 again. What we say about an implied term is that if it's needed, it's a straightforward one, based on a common understanding of contracts of this type, and I've covered some of this. Lady Justice Asplin did refer at paragraph 41 to the test in Marks and Spencer and BNP Paribas. We adopt what's said there. We point out, my Lord, contrary to some of the written submissions for the appellants, the test is the notional reasonable person in the position of the parties, or notional reasonable people in the position of the parties. It's not the parties themselves. So when it's said that, well, Mr. Barton might not have agreed to that, or Foxpace might not have agreed to that, well, that's not the right question. The question is, what would reasonable people in the position of the parties have done? And we say, looked at objectively at the time of the introduction agreement, there can really only be one answer to that question, because Mr. Barton, Foxpace want to sell the property. Mr. Barton knows of someone, a cash buyer, who's prepared to buy the property. Introduction fees are standard in this realm. Foxpace had agreed to pay substantial introduction agreements to at least 2 other introducers, and that's dealt with at paragraph 103 of the High Court judgment. So if Mr. Farnham, or I think it's a Mr. Hussain, had introduced a purchaser of the property, they had written agreements that would have entitled them to figures that are either side of the amount the judge reached for Mr. Barton in his alternative judgment. That's not quite the right phrase, alternative judgment, but the court knows what I mean. When he found value, notwithstanding that he found it wasn't to be awarded. So you have these 2 potential...
Where do we find the reference to that in the judgment, you said?
So paragraph 103 is where His Lordship refers to, and I'll give you a page reference if you just bear with me, my lady. So paragraph 103 is page 229. That's where he refers to, and it's over the page, sorry, page 230. That's where he refers to Mr. Farnham and Mr. Hussain. And then it's later on in his judgment where he then, page 252, page 252, paragraph 213, where he then refers back to the figures that he had. He doesn't name the people again, but my reading of the judgment is it's those 2, where he does above Mr. Farnham.
You say the test is what reasonable people would have done. And why wouldn't reasonable people have just agreed a pro rata reduction of the 1.2 million?
Well, of course, they may have done that, but one has to look at what's the term that would normally be implied in this situation, what's the common term that's implied, and on balance of probabilities, it's more likely that they go with what the common understanding is. That's what the cases like Devaney and Wells tell us.
The test surely isn't what reasonable people would have done, it's what a reasonable person looking would understand the parties to have done, which is rather different. I mean, we're told throughout the law that terms aren't implied just because they're reasonable.
Yes, for the purpose of the test of implying terms, it's of course you have the officious bystander test, where it's what would the officious bystander have suggested to the reasonable people in the position of the parties.
It's not the officious bystander who suggests things. The officious bystander says what's going to happen, or do you intend X to happen? He's not recommending any particular outcome to the parties, and they're supposed to say, yes, of course, that's our intention. But didn't the judge find that actually there was no common understanding as to how they would have responded if someone had asked them what's going to happen if it's less than £6.5 million. They would have said, don't be silly, of course it's going to be £6.5 million. We do not contemplate any other possibility. That was the finding.
What I said, the judge engaged in the wrong exercise, I say, because he rather than looking at a hypothetical situation, rather than looking at what the reasonable person would do, he looked at what the actual parties would do in a hypothetical situation, which I think is paragraph 21 of the Marks and Spencer case, where Lord Neuberger says what the way to look at it is. I'll just try and turn that up.
I mean, there could have been a construction of the contract under which parties could be reasonably understood to have agreed what a reasonable fee should be, but that wasn't what the judge was addressing. He was, as I understand it, he was addressing a situation in which it's as a matter of law, he thought on an unjust enrichment, but the same would apply if it was a term implied by law. There's a right to a reasonable remuneration. And then the law says, as I understand it, at least the implied term, that it's a market value of the service normally.
Yes, that's right. In many ways, what is required in assessing the market value of a benefit, as Lord Wright explains in Fibrosa, is very similar to what has to be done in the sense of implying a term, in the sense that what one does is ask what notional reasonable people in the position of the parties would have done, rather than hypothesise about what these actual parties would have done. Because, of course, you're trying to interpret an agreement, and we don't do that by looking at subjective intention anymore when we're implying a term than we do when we're construing the agreement. So it's paragraph 21 of Marks and Spencer, where it's Lord Neuberger who puts it in this way. He says, if you want to put, that's page 1081 of the electric bundle. He says, one is not strictly concerned with the hypothetical answer of the actual parties, but what that of notional reasonable people in the position of the parties at the time at which they were contracting. And I say, well, if you go back to the position at the time of contract, notional reasonable people, Mr. Barton would be in the position of having a purchaser who he wanted to introduce, but only if he was paid for it. Foxpace is in the position of wanting the name of that purchaser, but knowing that Mr. Barton expects to be paid for it. What other agreement would reasonable people reach other than that there would be payment for that? And the law tells us that that's of a common understanding, or the default position is that it's a reasonable amount.
And the reasonable amount is normally the going rate. And he could have had expert evidence, but he didn't. So he went on what other introducers of the property were, what was agreed in their case.
No, so the judge did the best that he could with the evidence that he had before him, and used what, in fairness, experts probably would have done little other than point to what might have been agreed in other cases to their conclusion. Of course, Mr. Gwyn-Jones himself, and I know I've just said subjective intention doesn't come into it, but just to make a liar of myself on that, Mr. Gwyn-Jones himself says at paragraph 101 of the High Court judgment that he would have wanted to renegotiate if the purchase price wasn't 6.5 million when he was asked him questions. That's page 229. Paragraph 101. He said, I would have wished to renegotiate with Mr. Barton. So there was an acceptance that there would have been that renegotiation. I wanted to just come on, but as I say, Marks and Spencer and BNP Paribas is a case of a detailed written agreement again, interpretation in that case. I wanted to ask the Lordships to look at the Phillips and B Sky B case, which is at page 1135 of the bundle.
So what's the page number again?
It's 1135, my lord.
Thank you.
That's the start of the case. And
1135, yes.
yes. And then I wanted to take your lordships to page 1144, particularly in the judgment of, and I think I said it was Lord Bingham before, I'm not sure if I got that right or not, I think it is.
It is Lord Bingham.
Yes, thank you, I'm grateful. And he mentions BP Refinery, that case at the top of the page. But he says in the second paragraph after that about the court's usual role in contractual interpretation, and in the next paragraph about there are, of course, contracts into which terms are routinely and unquestionably implied, and he gives examples. He says, towards the end of that paragraph, again, quite apart from statute, the courts would not ordinarily hesitate to imply into a contract for sale of unseen goods they would be of merchantable quality, etc. Hard to imagine trade conducted in the absence of express agreement on any other terms. And what I say, well, read for the implied terms in contracts of sale of goods as to quality, etc. Read for that the implied term that a reasonable sum will be paid, which is also in the Sale of Goods Act. It's in the Consumer Rights Act now, and it's in the Supply of Goods and Services Act. So these are not the same types of clauses as one's looking at in a Marks and Spencer and BNP Paribas case. And he then goes on to explain that a little bit further in the paragraphs that follow. And he says, just under the quotation indented on page 1145, that there could be little room for doubt what parties' joint answer would have been had the question been raised about what will happen in such a case. And he says there would almost literally have been only one possible answer. Then he goes on to say what matters for court attached importance to in reaching their approach to implication of terms in this particular agreement, including the fact that the agreement number 1 was containing a letter of nearly 8 pages which showed every sign of careful professional drafting. As I say, very different considerations apply if you're looking at a brief oral agreement, which is obviously incomplete. So, on the basis of that case as well, we say that it is a case like Devaney and Wells. It's more than that in the sense that it's a straightforward, reasonable remuneration claim of the kind that is implied by statute, if there's no mention of price, which the 18th and 19th century cases on quantum merit support as being implied by law. And you can look at the cases of Prickett, Lawford and Craven Ellis, which are in the bundle in relation to that. And we say properly read, that was the basis on which Lord Justice Mayles and Lord Justice Davis made their implications, or said that they would be prepared to imply a term.
And you say that this all applies here in a standard term, in a standard way, despite the existence of the actual agreement, because the actual agreement was limited to the circumstance where the sale was for 6.5 million. So when it's not for 6.5 million, you put the contract completely to one side and it becomes an ordinary reasonable remuneration case like Devaney and Wells, like all these other cases you've been taking. That's the argument.
Essentially, that's the effect of what we say. I wouldn't necessarily put it into quite such stark terms, my lady. It's a product of, what I say is you have to construe the agreement. Once you construe the agreement and say, well, the agreement says nothing about a sale at anything less than 6.5 million, but doesn't exclude remuneration at that level, then the effect of that is, because it's a brief oral agreement and it doesn't really say a great deal else, then the effect of that is essentially that it's almost like the agreement's been put to one side, but it's still fundamentally an agreement to provide services. It's almost like there's 2 stages to the agreement, my lady. You have an agreement, I will introduce a buyer, to you, and I will be paid on completion of the sale. And if the sale is at 6.5 million, you pay me 1.2 million. If the sale's at any other price, then I'm entitled to a reasonable remuneration. Just forgive me, I've lost where I was headed towards. I was going to the respondent's case, and paragraph 72 of that document, which is page 163. So what we say here is that what Lord Justice Davis did, and Lord Justice Davis, if you recall, preferred the contractual analysis in the Court of Appeal. And it's apparent, we say, from paragraph 72 to 75 of his judgment, that he had in mind the sort of straightforward contractual quantum merit that I've talked about. And I say that it's also clear from paragraph 75 of Lord Justice Mayall's, and that's clear in particular from paragraph 75 that he would have considered reaching that by construction as well. And paragraph 63 of Lord Justice Mayall's judgment indicates that he was also looking at it. It's said to be an elliptic reference in the appellant's case. I say actually it's quite clear to what Lord Justice Mayall's is referring there. It's a typical contractual quantum merit for a reasonable sum. And so we end up, in my submission, in the territory where only a clear express term displaces the normal situation, like in Devaney and Wells, and see paragraph 26. And move on to the unjust enrichment case. I want to begin by looking at section D of our case, and section 2 of that, the unjust factor. It's likely in my submission that the difference between us on this issue comes down to a question again of how you interpret the introduction agreement. The restatement at section 15 deals with the position on a failure of basis case generally. I wanted to mention in particular the case of Fibrosa as by way of explanation of failure of condition, because we say, as you see from our written case, that this is a case in which Mr. Barton provided and Foxpace accepted the work that led to a successful sale on the basis that Foxpace would pay for it, and a failure to pay for the work done means that the agreed condition for its provision has failed. And he therefore has a claim in unjust enrichment. And I'll come on to free acceptance shortly, but...
Sorry, does that you then say what you say, that what is the basis then which has failed?
As in the unjust factor, my lady, we say is failure of condition or free acceptance, depending on whether the court takes a view that free acceptance is a factor that can be accepted as an unjust factor. There's some doubt about that, as your ladyship knows.
If you could just explain that again, because I would just like to know exactly whether it's free acceptance or failure of a basis, and what the basis is.
Yes. Well, we deal with this in our written case of paragraph 82 through to 98, which is page 165 through to 170. But essentially what we say is this: that for the purposes of unjust enrichment, you're looking at what was the basis on which the benefit was conferred on the recipient. We say that it was conferred on the recipient on the basis that we would be paid for providing it. And we say that was the condition or consideration or the basis.
For that you relied upon an implied term. You're back to the construction of the contract.
No, we don't, because for two reasons. One is I say we can construe the agreement to mean that we, as I've already explained, you can construe it, which doesn't necessarily need an implied term. Secondly, for the purposes of unjust enrichment, you're not just looking at the contract, you're looking at what was the agreement in the wider sense. So unjust enrichment, whilst obviously still an objective assessment, so it turns very heavily on what the correct interpretation of the express agreement is. They're not necessarily one and the same things. So you look, well, what was the condition on which the work was done?
It's not. What is the basis? I think we're trying to get, because what you've just said, I thought was different from what you said in your case. You said that Mr. Barton provided the introduction on the basis that he was going to get paid. He's not been paid, and so there's been a failure of basis. But that wasn't how I understood you to be putting the case before. That's using basis in a slightly different sense.
Well,
basis is not the same as condition.
Perhaps it's my loose language, my ladyship, I apologise. So myself and the appellants have said that in the cases and the academic commentary, the different terms, failure of consideration, failure of condition and failure of basis are used in different places by different judges and different academics.
Right, but if the failure of basis is what makes it unjust for Mr. Barton not to be paid, but it can't be the case that the failure to pay him makes it unjust for him not to be paid unless they were under some obligation to pay him. So what is the basis on which he was entitled to be paid, which has failed?
Well, this again is why we come back to the question of construction of the agreement. So we said the correct construction of the agreement is that Mr. Barton was entitled to be paid for providing the introduction if a sale completed, and he was entitled to be paid a reasonable remuneration in the event that the property was sold for anything less than 6.5 million. So we say that's the contract between the parties.
Well, that's right. You don't get to unjust enrichment.
Well,
you don't need to.
Of course, I'm happy to accept.
If that's right.
Yes, although
we're looking at the unjust enrichment argument on the basis that that's not right.
Yes, although liability can be concurrent for unjust enrichment with contract. There are arguments against that, like my learned friend refers to in Mann and Patterson, but those cases are cases where there is a liquidated contractual sum that's due, and you are saying, well, rather than do that, of course, what happened in Mann and Patterson was that the claimant wanted more than they were entitled to under the contract. That isn't the case like this. We're saying we've ended up in a situation where the express terms of the agreement provide a price, but they only provide a price in one scenario. We're in a different scenario where we're entitled to reasonable remuneration. And we're entitled to that reasonable remuneration either on a contractual analysis, or you can say, well, if that's what the contract says, or if that's the correct construction of the contract, then that must be the condition for unjust enrichment purposes on which the performance was made, although it could also be broader. And therefore, you also have a claim in unjust enrichment. You only don't have a claim in unjust enrichment if for some reason not that those provisions don't apply and what's been put forward is the subsisting contract principle. Then one has to look at, well, what are the justifications for the subsisting contract principle? And what we say is, well, what's been put forward ultimately about Mann and cases like that, well, they don't apply here because we're not seeking more than is due under the contract. We're seeking the same award on either analysis. So I said either is open to us, but of course it's right to say, and it's perhaps a traditional approach, that if there's an awarding contract, the court doesn't go on to consider unjust enrichment. But that's not to say that it couldn't and it shouldn't. Just to go back to my ladyship's question, the other thing we put forward is it's not only we say counter-perform, and it's the performance of the promise rather than the promise itself that is the consideration in this sense. I'm sorry, I was explaining there previously. Failure of consideration, failure of condition, and failure of basis are often used interchangeably. My learned friend and I have settled on failure of basis as a terminology we'd use in our written cases. I may have forgotten that during the course of my oral submissions, but when we say failure of basis, we're meaning the same thing as failure of consideration or failure of condition. Really, in my submission, the easiest one to understand it on is...
Failure of consideration and failure of condition are two very different things.
not in the context of unjust enrichment in my submission. So, because where you started with a lot of this was in the Fabrosa case, where what was talked about was consideration. And the condition on which the work was performed was for consideration that was due. There are then cases that look at the consideration of a condition more broadly, which are the Barnes case or Roxburgh case. But it's quite clear from the Fabrosa case that when you're talking about restitution and you use the terminology failure of consideration, it means something different to consideration in the sense when you're forming a contract. And so condition in this sense is meant to mean what is the basis, what is the exchange for which you've entered into the contract. So in that sense, it is being used in the same sense as consideration, albeit that it can be, as I say, broader. And the broader basis on which we put our case is we say, well, first of all, if you agree with us on our interpretation, then you have a failure of condition on which we provided the performance, which is for counter performance, which is payment. It's not the promise of payment, it's payment. And it's payment of a reasonable sum. If we don't achieve that, we don't receive that, then there's a failure in that very straightforward, what I've called in the written case, orthodox sense. The other way to look at it, as we've put, is well, you could say that the basis or the condition of this case was that Western would pay £6.5 million for the property. And since they didn't do that, that was the fundamental assumption that the parties made, that they would pay £6.5 million for the property. It was outside of their direct control whether they did or whether they didn't. And when they didn't do that, the basis of the agreement failed. And in that sense, it's similar to the Barnes case, to the Roxburgh case, and you could say it's similar to the older case of Jennings and Chapman, where Lord Justice Denning certainly analyses it from a point of view of fundamental assumptions having not been achieved and risks not having been, the risk not landing with particular parties. So I've gone off on a bit of a tangent there in answer to questions. I'll just go back to Fabrosa if I could. So Fabrosa was the case that we take as our starting point. There, they were dealing with a situation that the courts had been holding that there was a rule that where a contract was frustrated and parties were released from further performance, that meant that advance payments made under a contract couldn't be recovered. That was on the basis that the claim couldn't be brought on the contract because the contract had fallen away by way of the frustration, but the obligations prior to frustration remained valid. So it was said, well, you've made the payment under a valid contract, you can't recover the payments now because the contract no longer is in force. And that was a rule in Chandler and Webster that loss lies where it falls. Fabrosa exploded that notion by explaining that the basis on which a party could recover advance payments made under a contract was that those payments were made on condition or in consideration of counter-performance. And so where frustration prevented the counter-performance, not the contract, it's the contractual promise, but the counter-performance, then parties could recover that, and they could recover it in what we now understand as unjust enrichment. And then it was the action for money hadn't received for failure, as I say, failure of consideration.
Can I just say that at the moment, it looks to me more attractive the way you've put this at paragraph 94. The reason I say that is that the way in which you put it in terms of the failure of basis being just that it wasn't paid for, well, there was no obligation ultimately to pay that money unless 6.5 million was paid for Nash House.
Well, again, we come back
There's
to
no breach of promise, which would be the sort of orthodox way in which one would deal with this, and then the claimant might have a choice of either enforcing the promise itself, which is what you would normally expect, or conceivably terminating the contract and then going for the failure of consideration. But that's not really an issue, it seems to me, in this type of case. You're not terminating for failure to pay. So I would have thought that what you say at paragraph 94 is the much more natural way of thinking of the failure of basis.
Well, of course, we put them both forward, and that they are those alternatives. We would, of course, be content with either analysis. We say it comes down again to a question of contractual interpretation. What is the interpretation of the introduction agreement? And then from there, how do you then interpret the wider bargain for the purposes of unjust enrichment if there's a difference between the two? I'm just looking at the time.
I also have some difficulty about the alternative way, because at page 246, paragraph 187, the judge makes a finding that didn't address the negotiations in particular circumstances. It just didn't think, in effect, about whether it would achieve 6.5 million. But what would happen if it didn't achieve 6.5 million? And I just wonder why. Certainly, Mr. Barton would have assumed that it was going to achieve 6.5 million. I just wonder why the vendor assumed, why it was a joint assumption.
I'm sorry, could you give me a paragraph reference?
It's 246. Sorry, page 246, paragraph 187.
Yes, well, of course, if they don't address their minds or their negotiations, and he said he found in the end neither party contemplated a sale at less than 6.5 million. Well, the inverse of that is if they didn't contemplate a sale at any other figure, then they assumed that a sale would take place at that figure.
I mean, the vendor doesn't even know who the purchaser is. He's got no idea.
Yes, and that's why they're proceeding on the fundamental assumption that the vendor is going to pay 6.5 million. Neither party's contemplated anything else. They're both assuming that's going to be the price.
I mean, Lord Stevens is raising scepticism as why a vendor would think that, but that seems to be what the judge concluded from the evidence of Mr. Rook. Is that right? Mr. Rook's oral evidence suggests he did not have the issue in mind.
Yes, that's right. I mean, those are the judge's findings. He saw the witnesses, and that was his finding of fact that they hadn't contemplated it. And it was consistent with Mr. Rook's own evidence, actually, which I think I mentioned this paragraph earlier, paragraph 111 of the judgment, where he says Mr. Rook said there was no discussion, or maybe something slightly more than contemplation, a discussion. But it was certainly consistent with the fact that he finds no contemplation at all. And if they don't contemplate a sale at anything other than 6.5 million, then they're assuming that that's going to be the sale price in my submission.
I'm struggling with the notion that a complete non-contemplation that it might sell for less than 6.5 million really stands very happily side by side with including the reference to that price in the contract. If your contemplation is that if this sale goes through at all, it's going to go through for 6.5 million, you might just as well say you get your money if there's a sale.
Well, again, Lord,
but if you say you get your money if there's a sale for 6.5 million, you're necessarily contemplating A, there may be no sale, and B, there may be a sale for less than 6.5 million.
Again, my Lord, we come back to the fact that the judge has found what the agreement was rather than express words as to what was said. He finds that was their agreement rather than that's what they said. And in many ways, the witnesses are consistent with that, and they're saying, well, we didn't actually discuss anything else. And Mr. Rook says, that he considered it was obviously subject to contract, but that isn't ultimately what the judge finds. He, in that sense, rejects his evidence because he finds that neither party had anything in mind at anything less than 6.5 million.
It's particularly strange given that the chronology which the judge sets out at page 218 recounts various recent attempted sales, all of which were for less than 6.5 million. And those didn't go through.
Yes.
Perhaps because they were for too little money.
But the basis must be a shared basis. All you get out of 187 is that was Mr. Barton's. view.
Sorry, I missed that one.
A basis within the context in which we're talking about failure of basis must be a shared basis.
Yes.
But all you get out of 187 is Mr. Barton's private view about the matter.
Yes,
It seems wholly unlikely that would be shared,
well,
because he hadn't even told Fox Pace who the purchaser was.
I'll give the quote. The relevant the paragraphs that I rely upon were referred to in our written case, so I'm just trying to...
Well, you write 189, for example.
It may be 189, my lord. Yes, thank you. 189. I think there's... yeah, so he deals with it. So it's up to and then 189, I think, is where he draws it to a conclusion. They had no shared or even individual expectation.
But that doesn't say they had a joint shared expectation that it would be sold for 6.5 million.
No, it doesn't.
And he says in circumstances which were not contemplated, that could just mean to which they didn't address their conscious minds. But it seems unlikely to have meant in circumstances contrary to a shared assumption that it would go for 6.5 million.
Yes, it's clear that they had not come to any shared agreement as to what Mr. Barton would be paid if the sale price was less than 6.5 million. And they may not even have discussed amongst themselves what would happen separately.
Yes, well, I say if neither of them has got any expectation as to anything other than a 6.5 sale, 6.5 million pound sale, then the inverse of that is they're both assuming that the sale is 6.5 million pounds for the purpose of this contract. I don't think I've come back to a free acceptance, which was, I think, my Lord Stevens' question some moments ago, and I apologise for going off track. But so we say failure of condition, but we say...
I just wondered, I'm sorry for dropping, free acceptance. It certainly wasn't free. They were going to pay 1.2 million.
Yes, it was free acceptance in the sense of they weren't obliged to accept the introduction, they chose to accept it. Yeah. And so we say, well, this is one of those cases where really there is no intellectual difficulty with saying that free acceptance is an unjust factor, because it's really just the other side of this being a failure of condition. In other words, if it's right that there was the introduction was provided on a particular basis that was a basis that was accepted by Fox Pace, then you could say on another analysis, well, they freely accepted the introduction.
So you go back to the contract, basically.
Again, yes.
But if you're right that Mr. Barton gets the 1.2 million if it sells for 6.5 million, and he gets a reasonable fee if it sells to Western for anything less, were Fox Pace nonetheless entirely free to reject an offer from Western for anything less than 6.5 million?
Well, they could have, at that stage, they've had the benefit of the introduction. They could either renegotiate or they're left in the situation that the law imposes the obligation.
So is the answer to my question no? Once the introduction has been made, they are obliged to accept the offer that Western make so as not to deprive Mr. Barton of his
No.
Or how does it work then?
Well, what Fox Pace can do as they choose. If they accept the offer, they've accepted an introduction from Mr. Barton, a sale is completed, and he's therefore entitled to be paid because they've had the benefit of his services by way of the introduction. Or if you look at it on a contractual analysis.
But obviously they're totally free to turn down any offer if they don't want to accept it.
Yes. As I say,
that on any view is a risk he takes.
This isn't a Luxor and Cooper case. We're not saying that Mr. Barton's entitled to be paid unless the contract completes. but a contract to the purchaser that he introduced is an acceptance of the benefit that he provided them. I wanted just... I'm very conscious, I've only got 5 minutes left.
Yes.
We haven't talked much about the subsisting contract principle as an answer to this, although in some ways we've cut straight to the point, which was His Lordship, Lord Briggs's first question to me, which is, well, if a contract governs it, then we don't really look at it unjust enrichment, do we? We say that the subsisting contract principle, if there is one, is really just saying that when you come to consider unjust enrichment, you look at the contractual regime, and any award or any award, yes, has to respect the contractual regime. It's often talked about in the language of allocation of risk. That's been used quite a lot in academic text. It's used in the Costello case, even though we do say, as my learned friend acknowledged, that's a completely different case, because it's a case where A is trying to recover from C rather than B, that we call leapfrogging or incidental benefits. It's just nothing to do with a case like the present. And it's quite clear that what Lord Justice Etherton, Master of the Rolls, I think he was then, said, it's quite clear that from paragraph 21 and 23 of his judgment that he's dealing with that scenario specifically. We do say, look at the situation where a contract is anticipated, and what is said by Lord Justice Beatson, or Mr. Justice Beatson as he was then, I think, in Benurad and Compass. We'll deal with that paragraph 103 of our submissions. We don't accept the distinction that's put forward by the appellants between cases where there's no contract and cases where there is a contract, because we say logically there can't be such a distinction. In either case, the question is whether the work's been done under the ambit of the contract or otherwise, and recognising the sanctity of a contract, or the sanctity of contract without the article, involves recognising that there's no contract just as much as it involves recognising that there is a contract. In either case, you've got to consider, is unjust enrichment inconsistent with that? And it's simply incoherent to treat a party with an unenforceable contract more favourably than a party with an enforceable contract, so far as unjust enrichment's concerned. So we say ultimately that this is a case where the principles of no application, because it's clear that restitution isn't inconsistent with the agreement. If there's other policy reasons why contracts to be preferred, then that's another matter, but I don't make submissions on those. Ultimately, my lords, by way of conclusion, you're left with a situation where Foxpace agreed to pay Mr. Barton 1.2 million if a buyer introduced paid 6.5 million for Nash House, which would leave Foxpace with a net of 5.3 million. A payment by Foxpace to Mr. Barton of the market value of the benefit that he provided them, as assessed by the judge, which was £435,000, at a sale of 6 million to the purchaser that Mr. Barton introduced, leaves Foxpace with a net of 5.6 million. How can that possibly be said, in my submission, to be inconsistent with the contract, that a party ends up in a better position than they bargained for, rather than a worse position? And not one single case has been identified that shows that that's the result. And in my submission, it comes back to what my Lord Briggs says in Devaney at paragraph 62. It's difficult to imagine a contract that wouldn't make the client, Foxpace here, liable to pay, having received the full purchase price from Weston, who were introduced by Mr. Barton.
I can just bring you very briefly back to page 241, paragraph 161.
Yes, my lord.
The agreement, or the substance of the agreement, was that in the event the Nash House was sold to a purchaser for the sum of 6.5 million. But you're saying in the event that the sale was completed, and I think you're also saying that they would be entitled to payment out of the proceeds of sale.
Yes, my lord, that's right. By way of the common understanding of how introduction agency agreements would work.
Sold must mean completed sale, not just a...
I mean, we said at first instance that, in fact, an agreement positive that it wasn't just simply completion of the sale was too uncertain to be enforceable. That was rejected, and we say that you actually, if it's 6.5 million, then it must mean the common understanding that an agent paid out of the proceeds of sale on completion of the sale.
It doesn't give you a security. It just helps you identify the time when payment becomes due.
Yes, that's exactly right. Yes. Yes, it's not intended as a.
It's not the right to have it paid out of the proceeds. They can pay it over anything they like.
I was going to say, I'm not sure it's a contractual right. It's the common understanding is that is what will be done. Hence why it's payment.
Exactly.
Yeah. Yes,
That's what was going to put them in funds to make the payment if they didn't have any other funds for the purpose.
Yes, my lord. I'm grateful.
Lord Manodi, I'll try and be as brief as I can. Where it seemed to me we might have got to is that I think in one sense I'm right in that either there's an implied term for payment or possibly it's an express term, although in my submission it's very difficult to see how that works. Or if there isn't an implied term, possibly subject to the Roxburgh point, there's no unjust enrichment claim. And so really what one needs to address is the implied term argument, the one that my learned friend in fact disavowed he was taking at first instance. And really it's this point about the term implied at law that I wanted to come back to. I think where my learned friend ended up on that was to say, well, it's customary to imply a term for payment in this kind of relationship. But what kind of relationship are we actually talking about in this case? If one were to think away the agreement that was actually reached, which talked about 1.2 million being paid in a certain event, would one, on the facts of this case, where Mr. Barton wasn't an introduction agent, that's not what he was holding himself out as, and where there'd been an ongoing relationship between these parties in which Mr. Barton was a purchaser, potential purchaser. He was an actual purchaser, but the purchases fell through. And he was obviously seeking to recoup his losses, his 1.2 million lost deposits. That, in my submission, is not a situation in which there's a customary set of terms that one would normally expect to apply. This just isn't a kind of customary agreement. I think my Lord Burrows mentioned Liverpool and Irwin. That was dealing with a lease. And one can see that in a lease there are going to be certain terms, and you can say, well, this is a lease, and normally you have this or that. But this really wasn't.
Well, are you suggesting that if nothing had been said about payment, then it just would have been a freebie as far as your clients are concerned?
No, Lord, I don't go that far, and I take your Lordship's point about in commercial agreements people expect to be paid. But with respect, that, in my submission, is implied terms, implied in fact. It's because in normal situations, you look at all the circumstances, you look at what else was agreed, and you can see that it's necessary to imply a term. It's necessary for business efficacy. That's the whole point about the officious bystander and the business efficacy test. But that's not because, in my submission, there's a term implied by law into any kind of contract in which services are provided. That goes much further than any decided case about terms implied by law in my submission. Where you're talking about terms implied by law, you're looking at a particular nature of agreement, as I say, like the lease. And it may be even an estate agent type agreement. You'd say terms are implied by law, although I note that's not the way it was put in Devani and
No,
Wells.
there seems to be a sort of grey area, so that where it's a very common kind of transaction, which has, quotes, usual terms, quotes off, you may get there just by construction. That is, you may say, well, when the parties spoke and behaved to each other in the way that they did, I think I gave the example of somebody selling a broom on a
Broom,
doorstep.
yes.
You just take on board as read, if you like, which I think means construction rather than implied term, that X, Y, and Z provisions are to be included, are to be treated as included simply by their words and conduct, without even having to go down officious bystander roads.
Yes, but
That seemed to be the preference of the court in that case, albeit that the implied term alternative was looked at. Always assuming there's a difference between construction and implied terms, which, well, maybe there is, but maybe it's a matter for regret.
But is one implying in the terms which are the terms and conditions on which that estate agent usually contracts, on the basis that if you ring up the agent and you engage them, then you're assumed to be doing so on some contract, and it's likely to be their contractual terms, which may or may not be similar to customary terms, whatever those are. One would then get perhaps into a bind where the customer says, well, I was agreeing to pay you, but only reasonable terms. And the estate agent says, no, if you contract with us, which you clearly did from your conduct, you're agreeing to our terms. I don't know where one would get to with that. But
No.
it does make it rather difficult to rely on some customary contractual payment terms.
I think, if I may say so, the point in Devani was that the debate was about they hadn't agreed when the payment was going to be triggered. And one could say, well, in circumstances where you've said, I'm going to get 2%, it's almost like taking judicial notice of the fact that in estate agent type contracts, when you say I'm going to get 2%, that means 2% when there's a sale out of the proceeds of sale.
Not just when, but if.
Yes, Your Lordship, right. Yeah. And one can say that because it's a very common type of situation. And one doesn't really need to call evidence to say that in every estate agent case, although one might, there might be cases in which one might call evidence to show what customary terms were engaged. But my submission is that in this case, we're a long way away from that. This is really not an estate agent case. And entirely accept Lord Legate's point that it's not going to be a freebie. People don't expect things for free. But here, there was an agreement about remuneration. It wasn't a freebie. And the question then becomes whether you should imply into the express term that was agreed an additional term that if the success trigger wasn't reached, you'd be paid a reasonable rate anyway. In my submission, it's not, you can't start from the position that because there's a sort of customary kind of contract which has this in it, and if you don't expressly exclude it, therefore you've got an implied term. You're in the Marks and Spencer approach. You have to look at whether it's necessary for business efficacy and so on. And in my submission, it wasn't necessary for business efficacy in this case that any term should be implied. And as I say, I do rely on the judge's findings that it's impossible to tell what agreement the parties would have reached. And I accept, of course, that he was dealing with the actual parties there rather than hypothetical parties. But really, in my submission, it comes to the same thing. One simply can't say which of a number of different options would have been bound to have been agreed between the parties. There are a number of different possibilities, pro rata, reducing by 500, whatever it may have been. And that, in my submission, that's the end of it for an implied term. And it's probably why my friend didn't run it in the first place, because he didn't think he was going to get there. So
you might say that about a contract in which there's a sale of goods without a specified price. You can't know what the parties would have agreed. Could have been X, Y, Z. So what the law does in that case is it applies a default rule that it's the market price if there's no other indication.
Yes, but if there's no other indication, that's the point that I rely on. Yeah. But here there is. They did.
Well, I appreciate your argument that here they did cover this situation.
Well, it's like Cutter and Powell. There was a market price for second mates on this journey, and it was £8. But because he had agreed 30 guineas, and then died before he completed the journey, he got nothing. It wasn't because of any uncertainty about what a market price would have been, or what it was that he agreed a higher fee, taking the risk that if he didn't get to Liverpool, he got nothing. If he'd agreed £8, then he might have got something.
Yes. Well, it looks like that from the judgment, although one can't absolutely be sure. And it must, as my learned friend said many times, it must all depend on precisely what the agreement was in the particular case. But yes, in that case, a very old case, but it does seem to have been the fact that it was a much higher rate that he was going to get. The court then said, well, there was plainly I can't remember quite how your lordship expressed it, but the equivalence of risk. If he completed the voyage, he was going to get a very handsome reward, but if he didn't, he was going to get nothing. And in my submission, the same applies here. That's the natural way to look at this. Whether or not one reads paragraph 161 as the judge actually making that finding or not, but that is the natural way, in my submission, to read it. So I think that's all I wanted to say about the implied term point. I think just a couple of very, very brief points, if I may. My own friend mentioned the Prickett and Badger case, I think, a couple of times. If the court looks at that case, you should also look at what was said about it in the Luxor and Cooper case, because I think all of their lordships, I may be wrong, but all bar one, if not all of their lordships, criticised the decision in Prickett for various reasons. And I think Lord Wright actually went so far as to say it was incorrectly decided. My note is page 652. I don't think we need to turn it up. Free acceptance, I didn't really say anything about free acceptance. I just wanted to deal with that very briefly. In my submission, free acceptance just isn't applicable on the circumstances of this case. Free acceptance was a term coined, I think, by Professor Birks. I'll be corrected if I'm wrong, but and he gave his famous window cleaner example. And whether or not one agrees with whether there should be unjust enrichment in the window cleaner example case, what it's about is when somebody provides a service without being asked to provide it, you just turn up, clean the windows, and hope that you're going to get paid. And if the householder's sitting there and watches you do it, smiles and waves out the window, and then at the end says, sorry, I'm not paying you. I mean, there does seem to be something unjust about that, but that's not this case. Here there was not only a request, there was an agreement. And in my submission, that excludes free acceptance completely. we're either.
I think it was Gwyn-Jones originally, actually, who first used the phrase. But,
I apologise, my Lord.
Nothing turning on that.
Nothing really turns on it. Certainly, Professor Burke's had the window cleaner example. That bit I do remember. So free acceptance is a non-starter, and the Court of Appeal were right about that. And of course, to be fair to the Court of Appeal, when they're thinking about unjust enrichment, that was the way in which it had been presented as free acceptance, and they weren't looking at failure of basis because it hadn't been addressed to them in that way. But when one does look at failure of basis, in my submission, it all comes back to the contract. Either there was an express or an implied term requiring payment in these circumstances, in which case you don't need unjust enrichment at all, or there wasn't, in which case there was no failure of basis because there was no obligation to pay. And so you don't get unjust enrichment in that circumstance either. Subject, of course, to the Roxburgh point in paragraph 94 of Malone Friend's submission. But I think I don't think I really need to say anything more about that because your Lordships and your Ladyship addressed that point with Malone Friend, and in my submission, everything that was said there is right. There was no joint assumption, and they bargained. The parties bargained specifically about remuneration and the circumstances in which it would be payable. They contemplated, objectively, whether one likes it or not, they contemplated that the sale might not be at 6.5 million because that was the terms of the agreement that the judge found. And in those circumstances, you can't say that there was an assumption that the purchaser would definitely purchase for 6.5 million. The final thing I wanted to say was your Ladyship asked me about the Howard Holder case, and I did find it at lunchtime. I don't know whether it's reached you or not. If it hasn't, then I won't go to it now, but hopefully you should have it. It is quite an interesting case, quite useful. And it does deal with, interestingly, with unjust enrichment as well. And there was no unjust enrichment claim in that case, or didn't succeed in that case. So may I just have one moment just to make sure I haven't missed anything? Lord, unless I can help you further.
Can you just say, you just ran through it quite quickly, but it might be an point about, I think you said there was no joint assumption.
Yes.
So, and then you referred back to the interchange between the bench and
yes.
Mr. Pomfret. But what is your submission as regards to the judge's findings? I think it's paragraph 161 we've been looking at, or 189, as to...
yes, 189, no shared or even individual expectation. Well, yes, the judge certainly finds that Mr. Barton had an expectation. It would be 6.5 million. But in my submission, finding that Foxpace didn't turn their mind to it isn't the same thing as saying they had a positive assumption that the price would be 6.5 million.
Well, I think that's how the Court of Appeal interpreted the judgment.
Yeah. Sorry, what was how the Court of Appeal? Apologies.
But I think they thought that the judge had found that neither side had thought it was possible that the sale would be less than 6.5 million. I may be wrong on that.
Yes, I'm not sure whether they quite go that far. I'm just looking for it. But In any event, if they do, I'd say they're wrong, because that's not what the judge found. And just said they had no the fact that he said they had no shared or individual expectation isn't a positive start in terms of finding a shared assumption. So it's that there was no joint assumption that there would certainly be a sale at 6.5 million. And in any event, it's not really, we haven't had time to go to Roxburgh and Barnes, and I don't want to go there now, but it's not really the kind of assumption that was being talked about in those cases, not some sort of substratum or something that was, both sides thought this is definitely the case. We don't even need to negotiate about this because obviously the tax is payable on these cigarettes in the Roxburgh case. Obviously the receiver is going to get paid out of the assets of the companies in the Barnes case. We don't even need to think of it. We just don't need to go there. This is not that kind of case. They did think about whether there was going to be a sale at 6.5 million, and that's what they agreed about. And so you're not really into that kind of fundamental assumption in the Roxburgh case. And there's some interesting argument to be had one day about whether Roxburgh works at all, where you've got a contract that deals with the situation. But I'm certainly not asking you to find that it was wrongly decided, just that it doesn't apply in this case. It's a very narrow exception to the subsisting contract rule. Sorry, I'd finished once.
No, well, thank you very much. Thank you both, and your supporting teams for some excellent written and oral submissions, upon which we will now deliberate and let you have a judgment in due course.